Welcome to the Breakpoint Podcast. We have been talking a lot about the 2020 session of the Supreme Court, several religious liberty cases that were decided upon. And as I've said on Breakpoint a number of times, I think this is going to be a biggie. As Supreme Court terms go, the decisions that were made, the courses that were decided, the cases that were decided upon, and especially what it means for the future, I think this is going to go down as a significant one for religious liberty. But I wanted to have this conversation with someone who knows this stuff certainly better than I, the William E. Simon Senior Research Fellow at the Heritage Foundation, founder and editor of Public Discourse, public intellectual Ryan Anderson, and Dr. Ryan Anderson, which is something to mention as well. Author of When Harry Became Sally, Responding to the Transgender Moment, and Truth Overruled: The Future of Marriage and Religious Freedom. Ryan, it's good to see you again. Thanks for joining us on the Breakpoint Podcast.
Oh, of course. Happy to be with you.
So, Yogi Berra said predictions are dangerous, especially predictions about the future. I think that this SCOTUS term is a biggie. I think what was decided and how it was decided, who wrote what opinions and what they wrote, given the cultural moment we're in, is going to prove to be something that we're going to remember. It's setting up, I think, future decisions, future cases. What do you think? You think that's an overstatement? Is this an important session of the court?
Oh, I think it's hugely important, but to my mind, primarily because of the losses, not victories. Partly because the victories all should have been slam dunk 9-0 victories, but the losses, neither of which should have happened. The loss in the Bostock case, the Title VII cases, shouldn't have happened, and the loss in the admitting privileges case for the abortion law, which was, I guess, this time it was out of Louisiana. But why did the Chief Justice, who 4 years ago thought the law was constitutional, all of a sudden decide that the law is now unconstitutional? Right? Stare decisis doesn't, to my mind, provide a sufficient reason when your primary duty is to the Constitution, not to court precedent. So yeah, I agree with you. It's a big term. The three religious liberty victories are important, and we should celebrate them, but they're not sufficient. They're not enough. And we're going to be, I think, for the foreseeable future, we're going to be wrestling with, the variety of ways in which they're not enough.
Yeah, I think that's right. So obviously, folks like David French, and just recently on Breakpoint, I talked about a piece in the New York Times. Stanford Law School professor Michael McConnell basically said, look, this is great. Every time religious freedom is put before the court, religious institutions win. That's one of my big concerns. When you talked about the difference between the wins and the losses, I think the court has been on a track record of defending the religious freedom of religious institutions. But particularly in the Bostock case, it's kind of removed any ground for defending the religious freedom of religious individuals, particularly employers, at least in that case. And that seems to me to be this hard, fast line where religious freedom applies and where it does not. And that to me is a net loss for religious freedom. What do you think about that analysis?
Yeah, I think that's right. But I think you could probably even go a little bit deeper and further into this, in that from a perspective of truth, justice, common good, the Christian vocation is to see that man-made law, human law, reflects and embodies the natural law and the eternal law. Right? MLK is famous for citing both Augustine and Aquinas to say that an unjust law is no law at all. And how do we know if it's unjust? An unjust law is a man-made law that doesn't square with the natural law and the eternal law. And so to simply say something like, well, we have lots of unjust laws, but at least we have religious liberty exemptions, that's pretty thin gruel, right? Because our primary concern and vocation shouldn't just be keeping our hands clean or protecting, our island of liberty, our kind of oasis from a decrepit culture. Our primary concern should be, as culture makers, to see that law and culture embody the truth and that they cultivate the truth. They cultivate human flourishing. And so whether it's the court redefining what marriage is, whether it's the court creating a right to kill unborn babies, whether it's the court reading gender ideology into our nation's civil rights statutes. My primary concern with all those things is that they're unjust. They do real harm to the common good. And so if you then tell me, oh, but don't worry, religious institutions are going to be exempt. There are going to be certain protections for religious institutions. Maybe even religious individuals will have certain protections. I'm glad for that, right? I genuinely kind of cheer on the victories of the religious liberty lawyers who are litigating these cases. They're important, right? We should celebrate what Beckett's doing, what ADF is doing. But I think we also need to not give up on what's taking place in the broader culture and the broader legal culture. So one of the Supreme Court victories was on a school choice provision, saying that if government creates a voucher program, it can't exclude religious schools. I think that's a significant win. But that doesn't kind of absolve us of concern of what's going on for the vast majority of our neighbors who are being educated in public schools, right? Government-run schools that we call public, where they're being indoctrinated with the 1619 Project, they're being indoctrinated with the gender unicorn. Religious liberty is good, but it's not doing anything for those students. What about the secular girls who are losing athletic championships to boys who identify as girls, right? Religious liberty is important, but it's not doing anything for those high school athletes who are coming in second, third, and fourth place rather than first, second, and third place, right?
So let's talk about those girls in particular, because the Bostock decision had to do with Title VII of the Civil Rights Act. The decision around these girls will have to do with Title IX of the Civil Rights Act, with this kind of extension of protections to SOGI categories, even though Gorsuch did it certainly in an unexpected way, not the way that certainly some of the progressives on the court would have done it, and not the way we certainly hoped. He did. He was innovative. Let's put it that way. He was Anthony Kennedy-esque innovative, at least in what he did. But did the decision in the Bostock decision, because it's basically reading in SOGI categories to sexual discrimination, is there any way now to keep that out of Title IX now that it's been read in Title VII?
Yeah, I mean, that's kind of the question that all of this future litigation is going to be about. And so I'm the attorney at the ACLU or at the Human Rights Campaign. I'm already drawing up my argument to say, wait a minute, if discrimination based on transgender status is sex discrimination for employment law, Title VII, why isn't it discrimination for education law, Title IX, right? If anything, I mean, Title VII is part of the Civil Rights Act, which is of 1964. Title IX is of the Education Amendments of 1972, so that's even closer in
to today,
time.
right? Yeah, we don't have to go back as far in history. Right? Yeah. Mm-hmm.
Yeah. Now, what would this mean? So the logic of Gorsuch's opinion, let me just read you one sentence. He says, if the employer intentionally relies in part on an individual employee's sex when deciding to discharge the employee, M dash. Put differently, if changing the employee's sex would have yielded a different choice by the employer, a statutory violation has occurred. Now, change the word employer and employee to teacher and student or coach, athlete, or administrator and student, and then apply that to things like bathrooms, locker rooms, sports teams. If changing the student's sex would have yielded a different choice by the coach, then a statutory violation has occurred, right? That's the logic of the Gorsuch opinion that every progressive activist is going to be latching onto to say their preferred policy outcomes should govern in a variety of contexts. Now, I think we can push back because to take something like athletics, any discrimination case has to have similarly situated individuals. And you can say someone with male muscle mass isn't similarly situated to someone with female muscle mass, right? That's why we have separate athletic competitions to begin with. In a locker room, someone with male genitalia isn't similarly situated to someone with female genitalia, right? That's why we have separate locker rooms to begin with. Now, neither of those, to my mind, are primarily about religious liberty. Right? I think you can be a secular woman and not want someone with male genitalia in your locker room, not want to be competing against someone with male muscle mass, male bone structure. So I think we're going to both litigate and legislate on the merits of those claims,
Yeah.
and hopefully prevail. Now, if we lose on the merits, a religious liberty exemption is better than nothing, but we shouldn't pretend that this is actually like some grand compromise in which fairness has been achieved for everyone. It's actually a lot of people are getting unfairness, and we're getting an exemption from that unfairness.
Yeah, I mean, you don't need to be religious. Just ask J.K. Rowling and Martina Navratilova, right? I mean, they already agree on that.
Yeah.
Does this set up, and I guess I'm going back to this, the court as a whole, the decisions, I know you have to look at them individually, but looking at the whole collection, it just seemed like the court was willing to say this about religious institutions and this about the rest of society. And I guess on a what's the word I want to use here? It kind of almost on an in cultural ethos level, that more and more religious institutions are going to be ostracized into their own painted little corners of discrimination. In other words, okay, this is what we've decided for the world, about gender, about sexuality, about marriage, and about their children's rights. And you guys just exist over here. Now, and it feels like some people are going, well, thanks for our corner. We'll go over here and be happy. I mean, that's not faith. But that's my profoundly negative interpretation of what we got en masse from the court this term.
Yeah, and part of this is that it's not the job of the judge to be striking legislative compromises, right?
Yeah,
and so this is
good.
If there is to be some grand compromise, you get some protections, we get some protections, you get some of your agenda, we get some. That is like the quintessential legislative question, and it should be done by the political branches of government, the executive and the legislative branch. The fact that it's happening through the judicial branch, I think, just shows how dysfunctional our politics are right now. Right? Congress is gridlocked, and so the court is, taking up some of these issues. Maybe they're doing it intentionally, maybe they're doing it accidentally. David French has the argument that, Anthony Kennedy left the kind of like tea leaves in the Obergefell opinion about how a grand compromise could be struck. And now, Gorsuch and Roberts are implementing that. I mean, who knows? It could also just be that, this is what the judges think is simply what the law requires on these issues. And it happens to be that this year's set of cases gave us this kind of mixed bag of results. I think the more important question for us isn't, what's going on inside the heads of the 9 unelected judges who sit on the Supreme Court. It should be, what do we do as like citizens of a self-governing republic to ensure that our laws reflect the truth of the matter, right? To ensure that human law reflects the natural law. In particular, I think that might be a more Catholic way of putting it, a more kind of reform way of just saying, look, there are certain creational ordinances, right? There are certain things that come out of the Noahide covenant, and those are truths for all people, right? They aren't truths for the church, not just truths for the people of Israel, right? These are truths for all human beings, written into creation, right? Written into God's covenant through Noah with all of humanity. And for government to fulfill its creational mandate, it has to reflect these things. And so our role as citizens is to see to that, right? Making public arguments about public goods, public truths, public justice.
Yeah, and we, one of the hardest things I find, I speak to students throughout the summer in particular on marriage and family. And one of the hardest things to convince them, and they're Christian students, is that marriage is a human institution, not a Christian institution, that it was given to human beings as a good gift of God. But you don't have to be religious to see the strong evidence. By the way, I want to go back to something you said about trying to read Robert's mind and Gorsuch's mind. I'm going to be pretty snarky here, but if Occam's razor is to be applied, the simplest explanation for Gorsuch is that he's an Episcopalian, and the simplest explanation for John Roberts is that he's got a super high concern for the reputation of the court and balancing out against the other powers that be. But that's again my interpretation. Let's go to the Louisiana.
Can I say one thing on
Sure.
on your point about marriage? Because that's an excellent point. That marriage does double duty, right? It's both a human institution and a Christian institution, right? That marriage is under the jurisdiction both of the state and of the church.
And it's a
Whereas by
reality like
contrast, think of
gravity,
something
right?
like
It's like a genitalia. You see it, you recognize it. It's just in the world. It's not something
right.
that is a social innovation like a speed limit. You know, it's like gravity.
Mhm.
It actually exists.
But it's also, I mean, it's, if you think about this, that the marriage serves like a public purpose, and that's why it's a human institution. Get men and women to commit to each other as husband and wife, so kids have moms and dads. But it also serves a sacred purpose, right? And so different Christian traditions will view it as a covenant or as a sacrament,
Right.
but it's, you know, it's somehow a sharing in the inner life of the Trinity. It's a vector for divine grace, right? And so doing both of those things. By contrast, baptism and bar mitzvah, those are entirely sacraments, religious ordinances of the synagogue and the church, right? We don't have the state in the baptism business or in the bar mitzvah business, but we do have the state in the marriage business because it does both, you know, the kind of the civic and the sacred, the natural and the supernatural. And I think that's something that we really need to remind kind of next generation of people of, right? I think there's a temptation after a Obergefell to say, all right, well, look, so long as we can keep marriage good inside of our house of worship, that's all we need.
Yeah.
It doesn't have a public natural status and role and function as well.
Yeah. But I mean, but the cat's so far out of the bag. I mean, you know, we have this township in Massachusetts, I think, that has now decided to recognize polyamory as civil unions and hope that it gets challenged at the court so that it can then be decided on a state level and then, you know, make its way. I mean, it's interesting to watch all this. Let's jump over to the case about the Louisiana abortion law. Because some of the language in that case was so strong. And, you know, again, I share your confusion why John Roberts thought it was completely okay for Texas to have done this sort of, you know, restriction, but not Louisiana, particularly because the situation on the ground in Louisiana, I mean, Louisiana is not Texas and Texas is not Louisiana, right? I mean, so in other words, the impact that the law would have on abortion restrictions and the undue burden, another magical phrase that has been invented by the court, you know, just wouldn't have been as great. But basically in the kind of the language that the courts decided upon this, it's precedent, you know, essentially it's settled law. What is this going to do to future state level restrictions on abortion?
Yeah. So two thoughts there. First, let me say something to kind of, you know, defend Roberts, or not so much defend him, but give him his due. I mean, there is a sense in which stare decisis is something important, because otherwise you could just constantly relitigate things, right? So if you're on the losing side of a court ruling, just year after year after year, you keep reenacting the same law and retaking it up to the court. And so there is a certain logic behind why you do want to say, look, the court has already addressed this issue. And even though I disagreed with the court, because we've already addressed it, you know, I'm going to uphold the court's judgment, even though I was on the losing side of the court's ruling, right? Simply to say, all right, there's something to the argument. That said, if you think the court got it wrong and it's about something, you know, as essential as life and death, well, at a certain point, you got to correct the mistakes, right? And wouldn't you rather correct the mistakes sooner rather than later, right? So it's 47 years after Roe v. Wade, and we still haven't corrected that mistake, right? And so, you know, I'd rather correct these mistakes sooner rather than later, especially when they're big ones. And this is where I think Thomas's dissent in the June medical case is really good. He says, look, our primary duty is to the Constitution. And when it's obvious that we've gotten a case wrong, we have to, you know, admit error and fix it. So what does this mean going forward? I think there's some argument to be made that, and Carter Snead, a law professor at the University of Notre Dame's law school, has made this argument that one of the silver linings here is that what the Chief Justice did was actually restored the Casey standard rather than an expanded Casey standard that Stephen Breyer had given us in Whole Women's Health. So actually he narrowed the ruling from the Texas case, so it's more favorable to pro-lifers. And that perhaps what he's suggesting is, you know, bring me a case that directly challenges Casey and Roe, and let's actually, go back to the root of the bad precedents on abortion rather than, one of the branches. Again, who knows what he is thinking, but what I would do if I was pro-lifer is say, all right, if the admitting privileges you're not going to reconsider, let's do a 20-week bill. Let's do a fetal pain bill. Let's do a fetal heartbeat bill. Let's directly challenge parts of the Casey and the Roe regime and see if you're willing to stand on stare decisis there. Or do we now finally have 5 votes willing to say we got it wrong in Casey and Roe, and it's been long enough that it's time to admit that we got it wrong, right?
Yeah, and there's some state level legislations that I think are going to be challenged, right? I mean, Florida, just reenacted a parental consent law, for example, and it would seem like some of these things are. And then there was was it Alabama that just had another one just in recent weeks, I believe, about
I think that's right. Yeah,
about fetal pain. I want to go to something that you going back to kind of the court, whether this was a good court or a bad court, or a good term or a bad term. In response to the more optimistic view, and I think you were responding here maybe to David French or somebody else on Twitter, and Twitter's a dangerous place to get your source. But I'm going to quote you from Twitter. I hope no one ever quotes everything that I tweet. But you said, the fact that there were 15 flagrant religious liberty violations that rose to the Supreme Court in a decade is not a sign of a winning streak at large, but of a new and heightened hostility to religion. You sound like Chuck Colson, by the way, in the sense of culture being upstream from politics. But we had the same thought. I mean, for example, why would Pennsylvania possibly think they should take the Little Sisters of the Poor, a group of nuns, back to court after the court had already ruled against the federal government, with the same idea? Why would the state of Montana really believe it could get away with discriminating against religious schools after the court had so clearly ruled in Trinity Lutheran, right? So the fact that at the local level, the unelected Civil Rights Commission of Denver, Colorado, or, the state of Pennsylvania trying to do some form of state level Obamacare, why the fact that these flagrant violations of religious liberty that had been settled before, it tells me that we've got a real problem with the larger culture understanding what religious liberty actually is. And they see it basically, your mentor, Professor Robbie George, on a recent interview said, we've got to break this notion that religion is a personal private hobby, that people just like to do, like they like to knit and go bowling. Or even worse, it's seen as a license to discriminate, as we've seen in the law, from the lips of lawmakers in California, and I think Mayor de Blasio, even at some level. So I want you to go to that tweet and kind of just unlock what you said, because I think it's a very, very important point, that if we're just kind of sitting back waiting for the court to decide, it's going to be a long, painful several years.
Yeah, great question. And there are probably like a half dozen things that I want to say about this. So it might come
Have
out.
at it.
First, I mean, so like the original tweet, it was from Luke Goodrich, and Luke is a friend of mine. He's a top-notch attorney. He works for Beckett doing religious liberty cases. And he was just pointing out, look, there's lots of doom and gloom, but for a moment, let's celebrate something. We've had a remarkable winning streak at the Supreme Court protecting religious liberty. And I think that's true as far as it goes. And that's why, my response was to say, at the Supreme Court is doing a lot of work here. Right? We do have a winning streak at the Supreme Court, but the reason that you guys have had to go to the Supreme Court so many times and win these cases is that the larger culture and the larger legal world is incredibly hostile. And it's not just hostile to religious liberty, but it's hostile to the underlying values, the underlying truths that then create the religious liberty complaint, right? So if you don't redefine marriage, if you don't create a right to abortion, if you don't mandate contraception and abortion pills, then you don't have the religious liberty violations down the road, right? So part of this is that we have unjust laws to begin with that then create the religious liberty violations. And so, yes, we have some good victories at the Supreme Court on religious liberty, but that's only in the wake of a whole bunch of legal rules that get the nature of existence wrong, right? Yeah. That our embodiment as male and female, marriage is the union of male and female, every human being have intrinsic worth and dignity. It's only when the law gets all those things wrong that the Little Sisters of the Poor and Jack Phillips, et cetera, have to go to the Supreme Court. So then another thought is that the process is part of the punishment. Like, yes, thank God ADF took up the Jack Phillips case, and thank God that they took it all the way to the Supreme Court, and thank God that they won a 7-2 victory for Jack Phillips. But the number of years that he spent, I forget how many years, I think it was like 5, 6, or 7 years that he was.
Well, it was 7 years, and then the city and the commission went right back after him, and now the private citizen that initially is going after him a third time. So he's in round 3 of this.
Yep, and this time it's for a transgender cake. I mean, the citizen had asked for a cake. I think it was like pink batter with blue frosting to celebrate that, girl on the inside, boy. And of course, Jack Phillips can't do that cake. And we all know he can't do that cake. And the very reason why you asked him to do that cake was because you knew he couldn't do that cake, right? And then the harassment from the human rights campaign, all the various levels, the process is part of the punishment. And so I think sometimes that, those of us who do this for a living, right? I research and write and talk about these issues. Litigators litigate these things. The process can sometimes be enjoyable for the people whose vocation is to do politics and to do law. But for the person whose vocation is to care for the sick, elderly, dying, that process can actually be kind of grueling. And so this Little Sisters of the Poor have had to go to the Supreme Court 3 different times in the past 7 years. They've won all 3 times, and they're not done. The Attorney General of Pennsylvania said he's going to continue pressing this case. And Joe Biden said that if he wins November's election, he's going to take us back to where we were before Hobby Lobby. And the reason why is that the underlying, objectionable HHS mandate still exists, right? And so as long as that's still there, we're still going to be fighting about how broad the exemption should be. And that's what I mean when I say it's not enough. And that while we do have a great winning streak at the Supreme Court, this legal battle isn't over, most likely for the Little Sisters. I hope I'm wrong about that, but all of the kind of indications from Pennsylvania's AG and from Joe Biden is that, they don't think it's over.
Yeah, it's amazing. I mean, can we just leave those poor nuns alone? I mean, let them do the just remarkable work. Well, as we kind of wrap up here, Ryan, it seems to me that we've got, what does this mean for us? I mean, you do this for a living. Most of the people that are listening to this don't do this for a living. They're not professionals. Maybe some of them are attorneys. I'm sure there's more than a few, but, there seems to be, the kind of the short-term, strategy of elections matter and therefore the courts matter. But if we're just relying on that, that's a short-term strategy. What's the long-term strategy for people of faith? Maybe, and maybe for people that, they don't do what you do, for a living. They don't have that, position to speak, at various levels of cultural power. But we are dealing with kind of on the ground cultural confusion about the role of religion and the role of religious belief and the history of religious liberty and what religious liberty is and what it's not. How do we all play a role in that?
There are a variety of catchphrases I could use to capture this. The fertile shall inherit the earth.
Have some babies.
Destiny.
Hey, have some babies. That's a controversial thing. I don't know if you saw that, but in our Protestant evangelical world, Kevin DeYoung got in some trouble for saying that.
I think to a certain extent, the long-term, so if the short-term strategy is November's election, the long-term strategy needs to be fruitful, multiply, and disciple your children, right? Raise your children, form your children in the faith. Rod Dreher and I disagreed about one chapter of his book, The Benedict Option, and I think we need to be more engaged in politics. He thought we're too engaged. Mm-hmm. But on the rest of the book, I'm in complete agreement with Rod, and I think it's a beautiful book in all those other respects. I think the most important thing I can do is ensure that my children are believers, that they're saints, that when they die, they're friends with Jesus and they go to heaven, right? And that's the long-term strategy. And so in terms of public policy, religious liberty is vitally important, right? If I don't have the space to do that, right? If I don't have a school that I can send my kids to educate, if I don't have the freedom to homeschool my kids, should, that be what my wife and I choose to do to form them? If I don't have the ability to kind of have all of the various cultural, social supports that I need, because I can't do it alone, right? No man's an island, no family's an island. We're all kind of situated, embedded creatures. We're creatures of culture. We need all of that, right? But that would be the long-term solution. Now, between short-term being the next election and long-term being, the fertile inherit the earth, I think there are all sorts of intermediary things that we need to do. And then a lot just depends on what's your vocation, right? So in my context, it's been, exploring what's the underlying truth of the matter on marriage, on gender identity, on some of these debated questions of discrimination, and then trying to, articulate those truths in a way that's accessible and understandable to ordinary. Your vocation strikes me, you do a lot of that, right? You explain highly sensitive, controversial issues to ordinary people. So, and then the next step is, so then they can talk to the people in their spheres of influence. My goal here is just to say something with it, but to say something so our listeners right now then have a new arrow in their quiver, right? An argument, a way of expressing something to talk to their kids about, to talk to their neighbors about, to talk to their colleagues at work about, right? And it strikes me that that's the medium-term solution, right? That we actually have to evangelize.
I think that's so important. I think that's so important, especially for pastors, Ryan, and disciplers, that we just don't assume knowledge. And this is where I think also Rod got a lot right about the importance of institutions. There's that Vince Lombardi story that after the loss in the playoffs, he held a football up to his professional players and said, "Gentlemen, this is a football." And there's just so much of that we need to do. Gentlemen, this is marriage. Gentlemen, and we've done a lot of discipling and teaching about how to do marriage, right? How to have a happy marriage and a godly marriage.
Mm-hmm.
But I don't think nearly enough on what marriage is, to borrow T.S. Eliot's phrase, what marriage is for, what marriage is actually designed for. And that's just an important thing. Well, listen, Ryan, it's always good to talk to you. And I'm grateful for your take here on this Supreme Court term. Again, follow Ryan Anderson at the Heritage Foundation. He's the William E. Simon Senior Research Fellow. And also the founding editor of Public Discourse, which is a terrific publication that I think just carries a lot of weight, Ryan, in helping to explain and translate some very important things to a larger audience. Also, I always tell people where to follow us on Twitter, unless they're not on Twitter, and then I tell them stay away because it will make your life terrible. Not everyone should go on Twitter, but if people are on Twitter, that's one of the great places to follow you. Where are you? Give everyone your how to follow you on Twitter.
I am at Ryan T. and A-N-D, the first three letters of my last name. So at Ryan T. and.
That's a great place. He's very active there, sending out terrific resources and also making some public arguments. And I think a lot of them fall into that category, Ryan, of thinking, oh, I can say that. That's another resource. That's another argument. And that's one of the things that you do best. Good to see you, my friend. I'll let you go. Thanks so much for helping us understand this better.
Yeah, definitely. Thanks for having me. And hopefully next time we'll be in person.
Yeah, absolutely. After the virus.